I don't think so. Oh, okay.
Share screen, allow participants to share screen?
Yes.
Yep, that's clicked.
So I have to log into Zoom. That's the easiest way, to tell you the truth.
Do you want his number?
Yes, I think I could do it through the
Our website?
Yeah.
Okay.
We got anything else? We got anything?
No.
I think Fred's back from lunch, so if we need it. I think that's what I called.
Yes. It's connected to. I can start while this
Okay.
loads. Is that okay?
That's great.
Good afternoon. Can you please state your name for the record?
Sergeant Edward Henley?
And are you currently employed, Mr. Henley?
Yes,
Who is your employer?
the Huron Township Police Department,
And how long have you been employed with the Huron Township Police Department?
almost 26 years.
And what are your present duties with the police department?
I'm a road patrol sergeant assigned to night shift.
Were you employed in that capacity on June 20th, 2021?
Yes, I was.
And were you in fact on duty that day?
Yes, I was.
Pursuant to your duties as a police officer, did you have the opportunity to go at or near 35777 South Huron Road?
Yes,
And where is that located?
South Huron on Bell Road, west of I-275,
And what city is that in?
Huron Township.
And that's Wayne County, correct?
Yes,
What led you to that location?
I was called there on the report of the defendant trying to light a car on fire of his ex-wife.
When you arrived at that location, did you come into contact with Mr. Huddleston?
Yes, I did.
Do you see that person in the courtroom today?
Yes,
Can you please identify where he's sitting and what he's wearing?
to my right, he has a dark gray sweater on with stripes, darker gray stripes.
Noted.
Thank you. When you initially observed Mr. Huddleston, what were your initial observations?
He was standing behind a vehicle and he was smoking a cigarette.
And did you observe anything at or near his person?
A duffel bag.
Can you describe that duffel bag? Or-
I believe it was brown.
Upon making that observation, what, if anything, did you do with his belongings?
Well, upon arrival, I began to talk to him. And prior to arriving, I was advised he had a PPO on him with the protected person was inside the vehicle. And when I went up to start questioning, I was there by myself, told him, asked me, hey, weapons, I told him I was gonna pat him down. I then started pull away from me, told me he'd rather run than bleed. At that time, 2 Metro Park officers showed up, we got him handcuffed and we placed him in the back of my car.
And so, sorry, at that time then, what, if anything, did you do with the duffel bag?
I put it in my patrol vehicle.
And then at that point, did you convey Mr. Huddleston to the Huron Township Police Department?
Well, I had to talk to the victim first, get a statement from her, um, contact information from her. Then I went to the police department.
Okay. And were you in your squad car?
Yes, it's a fully marked patrol car, the light bar on top.
Okay,
Huron Township Police down both sides and supervisor on the front quarter panels.
okay. And is there a video in your squad car?
Yes,
So that's when, this is when I would like to play the video, but it's still connecting. Should I just keep?
Yeah, just,
Okay. While you were in the vehicle, did Mr. Huddleston make any statements regarding the PPO in place?
he stated he knew he had one. He wanted to get a truck or a
Objection, Your
vehicle.
Honor, hearsay.
Response?
It's the statements made by the defendant to his knowledge. I don't think that's hearsay if it's statements he has made to the police officer.
Any response, Ms. Vargas?
Judge, I would say that's not a statement against interest.
I mean, it's a statement of a knowledge of why he was being picked up by the police as a violation. Like
Also
he's-
sounds like it'd be against his interest if it was a violation of the PPO.
Sorry, say that again?
I said, also sounds like it would be a statement against his interest if it was admission that he was violating his PPO.
Correct.
I'll allow
Sorry, I lost my train of thought. Oh, yeah. So what else did he say to you in the vehicle?
Told me I was doing them wrong. You know, this is BS, stuff like that.
And then at some point you did convey him to the Huron Township Police Department.
Correct.
Okay. And upon conveying him, did you conduct an inventory search of his belongings subsequent to his arrest?
Yes.
Okay. Can you describe the search, please?
While he was in the booking room, his duffel bag was placed on the counter. I started inventorying the belongings. I believe there was like an iPad or some type of iPad, a wallet ID. I found a pill bottle that didn't have his name on it. I found another container that had what was ended up being methamphetamine, crystal meth. Some clothes, I think, and you know, personal belongings like that.
Okay, and the person you identified on the pill bottle, were they involved at all in this incident on that day?
No,
Did you see them anywhere, or did you identify anyone as that person on June 20th?
no.
And based on your investigation, do you have any reason to believe that the pill bottle did not belong to Mr. Huddleston?
I believe it did not belong to me. It had another person's name on it. It was, look at my report, Jessica Pauley.
Objection, Your Honor, he hasn't laid a foundation to be able to refer from this report.
Agreed.
Okay.
If you want the name and lay the foundation.
Okay. Whose name was on the pill bottle?
Jessica Pauley.
Again, objection, Judge, he's looking at his report.
I mean, I can move forward because that's not, I guess my question goes back to whether or not, based on your investigation, the pill bottle, if you believe the pill bottle belonged to Mr. Huddleston.
Objection, Your Honor, speculation.
Response?
Not necessarily. I mean, he picked up the duffel bag that was in Mr. Huddleston's possession. Based on his investigation, if all this stuff is the defendant's, he can make that sort of distinction based on his investigation.
I'll allow
It was in the duffel bag with all of Mr. Huddleston's possessions.
Okay, thank you.
it. Counsel, my tech guy's here if you need some help.
Hello. I am now in the waiting room,
Okay.
I think. Oh, no, it says, yes.
Ms. Vargas, you're in the waiting room too. Do you need
Yes,
to come in?
I am going to be playing videos as well.
Oh, lucky me.
I pick whichever one. Okay. Thank you.
I think we're good, Fred. Thank you.
Thank you. I'll just finish up and then.
Yeah,
okay,
whatever,
Okay.
however you want to do it.
Did you place the suspected narcotics into evidence?
Yes,
And to your knowledge, was the suspected narcotics submitted to MSP for testing?
yes,
And did you receive those results, the results from MSP?
the detective bureau would have gotten them.
Okay. At this time, Judge, I have the lab report that was already shared with defense counsel, and I have copies too, like physical copies. Oh, you're right, okay. That I would like to admit as post exhibit number 1 for the people.
Any objection?
Judge, I believe it's permissible pursuant to the statute.
I agree.
Correct.
Yep, that'll come in.
Can I, Judge?
Yeah, did Heather mark it already? Yeah, let Heather have it and she'll mark it.
And then do I hand these?
Sure.
Okay.
Counsel, this is page 1 and 2, same document, correct?
Yes. Sorry.
Proceed, counsel.
Okay. So at this time, I'm just going to play the video of the squad car video just to just a little bit for us to confirm that it is what we just discussed. Sergeant. I'm just gonna fast forward a little to the part that I.
Which file number?
Oh, sorry,
is
yes.
the-
This is the Fleet 2 video. I believe this.
Oh, the 214. Okay, I got it.
Yeah,
Thank you.
yeah, okay.
Mhm.
And will it work, the sound? How do I share that? I guess if I'm muted.
Yes,
I had no idea.
just unmute it.
I know how to send emails. That's about my technology.
And then if the TV in here is muted, we just need to make sure there's audio on the TV in here.
Well, that's.
Take my kids out and stuff.
You have to share your Zoom screen.
Sorry, say that again?
You have to share your Zoom screen if you want it. Oh, it is up there. Never mind.
It's just that doesn't have, I think, audio.
I just had some audio coming from somewhere.
Yeah,
It's,
That
it
was
was
her
from my
computer.
computer. Was that loud
Okay.
enough?
Let me hear some more.
And Judge, just for the record, she started playing at approximately 8 minutes and 8 seconds in.
Sorry, I actually would like to. I'm gonna find the spot that I'm looking at and then I'll note where it
Go
is on
ahead.
the record. It's just because I lost my place when I walked back in.
Fucking bullshit, man. Hey, you fucked up, bitch. You fucking lied to the fucking cop. That's goddamn fine.
Okay, I think it's so I'm assuming this was the spot. I'm gonna play it at 6 minutes for the record, just for the confirm the squad car.
You're picking that up, aren't you?
She tried to rob me. Pistol, man. She set me up, dude. To get my car that you guys told me to try to do. Work it out with her. I got screwed, bro. Yeah, that's fine.
Sorry, I'm just waiting for the officer to come back in. I lost my place where that was.
Judge, if sister counsel would be wanting to just pass the witness for now, so she can pull up the video, I can do my cross-examination.
Yeah,
That's fine.
okay, thank you.
Good afternoon, Sergeant.
Good afternoon.
So when you first arrived onto the scene, Mr. Huddleston was standing in the back. Yes. Mr. Huddleston was
Much
standing, I'm sorry, when you arrived on scene, Mr. Huddleston was standing at the back end of a Buick Encore, is that correct?
I believe that was the car.
And that was the vehicle that the complainant, Ms. Strickland, was in?
Yes,
Okay. And he did not try running when you arrived on the scene, correct?
correct.
And he actually walked towards you when you first pulled up and started walking towards the vehicle, correct?
I don't remember. I had contact with him.
Okay. And when you were speaking to him, he actually put his hands up over his head for a couple minutes while you were questioning him and patting him down, correct?
Yes,
Yes. And when he mentioned that he was going to run away, his arms were actually above his head, and he was in compliant with you when he made that statement, correct?
no, I was trying to handcuff him.
Okay. When you went to go handcuff him, that's when the two other officers arrived on scene as well, correct?
Shortly after when I was struggling with him, yes.
Okay, and the two other officers are identified as who?
I have to check my report. They're Metro Parks police officers.
Would that refresh your recollection if you refer to your report?
Yes,
You may refresh your recollection.
Mendritsky and Walzek.
Okay. So those two other officers essentially arrived as you were trying to handcuff Mr. Huddleston, correct?
Yes.
Okay. And those officers are part of Huron PD as well?
No, they were for the Huron Clinton Metro Park Police Authority.
Oh, okay.
It's common for them to back us up when we're busy. There's 3 Metro Parks in Huron Township, and they pass between them, and they help us and we help them backing up on calls
Okay.
when needed.
And to your knowledge, do you know if that department utilizes body cameras?
I believe they do.
Okay. As your role and officer in charge of this case, have you made any attempts to try to obtain those body cameras?
No, any case like this, I would do the original police report, then it gets turned over to the detective bureau because of the felony charges, and they would handle gathering any type of evidence like that.
Okay. Do you know in this case who in the detective bureau would have been responsible for that?
I can flip through my report again and see who submitted the warrant request. I can tell you.
Would that refresh your recollection?
Yes, it would.
You may refer to your report.
Looks like Detective Castle,
Can you spell that for us, please?
Kassem.
Thank you. I'm sure the reporter would appreciate that. All right, Sergeant, you also said you interviewed the complainant in this case, Mr. Strickland?
Yes,
Okay, and when you did that, Mr. Huddleston was already in your police cruiser, correct?
correct.
Okay. And when you guys first arrived on scene, she was in the vehicle with the window up, correct?
Yes,
So on direct, you testified that Mr. Huddleston had a pill bottle that did not have his name on it, but then you mentioned that there was another container?
yes.
Okay, can you describe the other container?
I would have to look at my report.
Would that refresh your recollection?
Yes, it would be.
You may refer to your report.
It was a green pill bottle and it had some pills in it and a bag with what I believe was methamphetamine in it. After
Okay,
tested, it was methamphetamine.
so there was a regular style pill bottle that was what, an orangish yellowish color, and then the other green one, is that correct?
I only have in my report there was a green one.
Okay. And does your department have an inventory policy regarding belongings at booking?
As in, it's put in on the booking computer and it's sealed in a locker within the booking area.
But is there a department policy regarding inventorying property upon arrest while going through the
Yes.
booking process?
Yes,
Okay. And can you explain the portion of the policy as it relates to inventorying, for example, a backpack or a duffel bag?
we would open it up, identify any contents. It's placed on the booking sheet. If any contraband is found, it is seized and placed into the evidence lockers.
Okay, so all of the property that is inventoried is outlined in the booking sheet as well?
Correct.
Okay. And then what was the second half that you said? I apologize.
Anything that is contraband is seized as evidence, tagged and placed in the evidence lockers.
Okay. I can have a moment, Judge. Nothing further for this witness, Judge.
Are we ready with the video?
My only issue is because I wasn't able to find or listen to it with the volume, like during this, can we take like a 5-minute recess just so I can, or even a 2-minute recess, just to find
Sure.
the exact time?
Yep.
Okay, thank you.
Judge Oakley only has video, not audio.
Still on the record, Counselor.
Okay, just to ask a couple follow-up questions. When you arrived on scene, what, if anything, did you know regarding the active PPO in place between the parties?
That per lien, it had been served.
Okay, and
Judge, I'd object to that as a hearsay statement.
His response that it had been served?
Via lien, yeah, that per lien it was served.
Okay. Response?
I don't think I would say that it's a statement. It's something that he observed himself before appearing on at the scene. It was part of his investigation before they got there to know what was going on, and so that's what he saw, his own knowledge. I don't think it would be a statement.
My understanding is either dispatch ran it and told you, or you looked at a screen and saw it yourself. One or the other, right?
Yes, sir. Would you like me to elaborate on?
Well, either way, I think it's a statement. Either he read it or somebody told him it's a statement, I think. Can I have a written can I hand him
Yes.
that and say that's a statement?
Yes,
Couldn't that
but
be
if-
hearsay? I mean, if it's a letter?
I guess what I was trying to get at is if that's part of why he was there, like knowing that, okay, this person is possibly violating the PPO, that goes a part of the investigation and his, I guess, knowledge about
So
it.
it's a statement, but it's not submitted to prove the truth of the matter asserted. It's just to show the officer's doing what he's doing, why he's doing it. I'm trying to understand the argument.
Yes, no, I understand what you're saying. I wouldn't say that because it would be showing that why he was present.
Judge, if I may, he
Sure.
didn't testify to responding for a PPO violation at all on direct. He testified that he was there for a different reason.
Right.
But I think that was, I guess, can I inquire more into that as to
Sure.
the response? Okay, so when you initially got the dispatch call, why were you, what brought you to the scene? What were the circumstances?
Huron Township Dispatch received a call of a subject standing on a car, standing behind it, not letting it back out, and trying to light it on fire. Dispatch received the complainant's information, the suspect's information, ran each one of them in lean, and then copy and pasted their information into my run sheet that would be on my laptop computer in my patrol vehicle. They advised me that the suspect had a PPO, it was in lien as being served. And it
So
was-
that, sorry to cut you off, but that would be the same thing if one of the people involved had an outstanding felony warrant, dispatch would let you know that as well, correct?
Correct.
Okay.
So I guess that's what I'm trying to get at, is like, if it's part of his investigation to move forward, I mean, yes, it's a statement, but it was something that was shared for,
Well,
So-
which one of the, all right, so we've agreed it's a hearsay statement, right? Or it's a statement, so we gotta find a hearsay exception. Give me one.
I guess I retract, because at this time I cannot find one that would work. So I take back the question.
Okay, next question.
Okay, so, okay, so I'm gonna play this video. You mentioned that you did have your squad car, or there was video in your squad car, correct?
Yes, ma'am.
Okay, and so,
And just for clarification of the record, is sister council moving for admission of this?
Are you there yet?
I'm not there yet, because I'm gonna have to have him, I guess, assert that it's his squad car.
Okay.
And for the record, we're starting at 13 minutes and 3 seconds, and I think I've lost my sharing abilities.
I got got set up, bro. I don't have people that can do this for me. Intermediates.
Down the street, there is going to be a transformer on fire. They said at this time it is catching trees on fire as well.
I'm going to jail, sir, for fucking hurtful setting me up in my car. I've been calling you guys all week now. Dude, I came here to get my car, dude. So when I got to have my car, she told me to drop the keys off. She says, come here. I was here.
So does that accurately identify your interaction in your squad car with Mr. Huddleston?
Yes,
Okay, now I move forward the submission of this as knowledge of not only the interaction that the sergeant mentioned earlier about the defendant's knowledge of the PPO, but also the defendant's statements regarding being there and accusing her of setting him up because of the PPO.
Ms. Fargus, any objection to the admission?
Judge,
of-
I have no foundational objection to this exhibit.
Thank you.
Okay. Those are all my questions. Thank you.
Okay, that'll be people number 2, right?
Yes.
Any other questions for the witness, Ms. Fargus?
I'm sorry, was there anything more to that video?
You can go for math.
Sorry, there was nothing further you were playing on the video?
I can play more.
I just wanted to double check. All right, just a couple. So Sergeant, when you placed Mr. Huddleston into the back of your squad car, he was handcuffed, correct?
yes,
And he was under arrest.
yes,
And did you advise him of his Miranda rights before you put him into the back of the squad car?
no,
Okay, and you would agree that there was some back and forth interaction between you and Mr. Huddleston in terms of the comments that he was making, correct?
correct, but I wasn't asking any questions.
Okay, what do you recall what any of your statements were? Because it was hard to hear on that video.
I just told him that he knew he was violating the PPO. He kept rambling that he set her up, that he was there to get the truck.
Okay, but so you did tell him that he knew that he had a PPO, correct?
There was some discussion, he knew he had it. This had been ongoing for several months in the township. We had dealt with him several times.
Okay,
and-
so you had prior knowledge of the history of Mr. Huddleston and Ms. Strickland based
Yes.
on your duty as a police officer?
Correct, yes.
Okay, but again, while Mr. Huddleston was in the back of that squad car, there was comments from you that he knew about the PPO, correct?
Yes,
And that was based on the information that was relayed to you onto the scene from dispatch, correct?
yes, plus.
As well as your personal knowledge that you had during, just the general business of your police officer duties.
Correct.
Okay, nothing further, Judge.
Any follow-up for the sergeant?
No, Your Honor.
Sergeant, you step down.
Thank
Thanks,
you.
sir.
Watch your step. Next witness?
Yes. The people call Nicolette Strickland. You want me to look at her?
Ms. Strickland, all the way up front. All the way up. Settle in there, set your purse down so you can raise your right hand for me and I will swear you in. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth today?
Yes.
Counsel, your witness.
Can you state your name for the record, please?
Nicolette Strickland?
Are you familiar with a Gary Huddleston?
Yes,
And how long have you known him for?
since I was 14.
So how many years is that approximately?
25, 27 years.
Okay. And what has your relationship been?
Friends, and then the last 13 years we've been in a relationship, romantic. We have 2 kids.
At any point were you married?
No,
Do you see Mr. Huddleston in the courtroom today?
yes,
Can you please indicate where you see him and what he's wearing?
at the desk behind you, gray sweater.
Noted.
Thank you. Are you familiar with 35777 South Huron Road in New Boston, Michigan?
I believe that's, yes.
What is that to you?
I
What
believe
location
it's
is that?
Chaps Landing,
And what is that?
gas station,
And what city is that in?
New Boston.
Do you recall an incident that occurred at that location on June 20th, 2021?
Yes,
And can you tell me what brought you to that location on that date?
yes. I was exchanging my blazer to Gary in exchange for what it cost me to get it out of impound.
So prior to meeting Mr. Huddleston at the gas station, can you tell me what, if any, interaction you had with him?
He emailed me
When did he email you?
starting on June 13th throughout, I think, the 15th or 16th.
Okay, and how many emails would you say you approximately received from Mr. Huddleston
Approximately over 10.
throughout those several days that you listed?
Yes.
And what were the nature of those emails?
Threatening me about getting the truck back.
When you say threatening you, can you please describe what you mean by that?
That if I don't give him the truck back, that he's going to show up at my house and harm me. And that just him calling me names.
Do you recall anything he said specifically in any of those emails?
Yes. He told me in one of the emails that his Uber would be there in 20 minutes and he would be at my house in 35.
And so during that exchange of emails, how did you feel receiving those?
Afraid, very afraid.
And at that time, was there any court order in place restricting Mr. Huddleston from contacting you?
Yes.
And what was that?
A PPO.
Do you remember when you got the PPO?
October of 2020.
And this incident occurred on June 20th, 2021, correct?
Correct.
Was this, to your knowledge, was the PPO still active when Mr. Huddleston was emailing you?
Yes.
Did you at any point prior to this incident attempt to terminate the PPO?
Yes.
How many times?
Twice.
But was the PPO ever terminated to your knowledge?
No.
Do you know whether, again, to your knowledge, Mr. Huddleston was ever served with the PPO?
Objection,
Yes.
speculation.
Yeah,
allow you
I was
to-
gonna say,
it
because her
depends on how
response,
she knows. She might-
exactly,
yeah,
her response would clarify that.
I agree.
Yes,
And how do you know that?
because I was there when New Boston Police served it to him at my house.
Okay. And at that point, or after that, or sorry, when did that happen?
March, I believe,
Okay, of what year?
2021.
Okay,
I'm sorry, can you repeat that month?
March.
March.
Okay, so going back to the date for June 20th, 2021. Did you eventually agree to exchange the truck based on the emails?
Eventually, yes,
Can you explain why?
because I was afraid that if I didn't give him the truck back, that he wouldn't stop and would show up at my house to hurt me.
And what did you do on that day when you agreed to meet with him?
I don't understand, what do you mean?
Did you agree to meet with him right away?
On the 20th, no, it would, when he started, from the time he started emailing me, it had been a week.
Okay. And then on the day that you met with him, did you suggest meeting at a specific location?
Yes,
What was that?
New Boston Police Department.
And why didn't you meet there?
I wanted to meet there. I'm sorry, did you say why?
I said, why did it? Yeah, why did you not end up meeting there?
Because he wouldn't go there.
And then next, where did you want to meet?
At Chaps Landing.
And when you arrived on that day, on June 20th, what happened at Chaps Landing?
When he showed up, I could tell that he was high, and he was screaming at me, because the truck wasn't right there visible
Where was the truck?
at Chap and Bushy down the street.
Okay.
And at that point, he was screaming at other customers as they were going in and out of the store about me, telling them that I was a B word and that I stole his kids. And at that point, I told him, I said, just give me the money, I'll give you the keys, you can go.
Where were you during this time?
Inside my vehicle with the window up.
And he was outside your vehicle?
Correct.
Okay, what happened next?
After he screamed more, I told him, forget it, I'm leaving. And then he took money out and put it underneath my windshield wiper. And I rolled my window down and tried to get it, but I couldn't reach it. So I opened my door and stood up on the ledge right there. And as I reached over to grab it out from underneath my windshield wiper, I seen out of the corner of my eye, his fist coming at me. And so I moved back and got back in my car and rolled up the window and called 911.
Okay. At any point, did any part of his body make contact with you?
Yes.
And what happened? Where was that contact?
My lip.
And what part of his body hit your lip?
His fingernail scratched me.
And were you able to leave that gas station at any point?
Not until after the police came,
And why was that?
because Gary sat on my bumper, so I couldn't back up.
And how long would you say that was for?
It felt like forever, but it was probably within, I think the police were there maybe less than 5-10 minutes.
Okay. And during that incident, how were you feeling?
Afraid for my life.
And at some point you were able to contact the police?
Yes, as soon as I got back in my car, I called 911.
Your Honor, if I can approach the witness, please.
Sure.
And I already gave a copy of this document to defense counsel. Oh, sorry, it is just the front.
Just the whole-
Yeah, but she's just. Do you recognize this? I don't know. Do you recognize that document?
Yes,
Does that document have your signature on it? If you want to go to the
Yes.
second page, it has the entirety of it.
yes, it does.
And how do you recognize this document?
It's the personal protection order,
And when is this personal protection order dated?
October 12th, 2020.
And is this the personal protection order that you mentioned that was in place when you had contact with Mr. Huddleston?
Yes,
At this time, Your Honor, the people would move to have this exhibit be marked as People's Proposed Exhibit number 3. It's a certified copy of the PPO that was in
Ms.
place.
Farkas.
Judge, I believe it's admissible. I have no objection.
I agree. Thank you.
Great, thank you. I can grab that. Thank you.
I'm sorry, you're admitting the whole packet or just the PPO?
Oh, I guess I don't need to do the whole pack. Would you have an objection if I did the whole thing?
I mean, I don't think the whole thing is relevant.
Okay, yeah, that's fine. It's just, it encompasses a lot, so.
Yeah, I'm okay with the first page with the certificate and then the PPO itself.
So 2-page exhibit.
Yes.
Ms. Mathesian, you agree? 2-page exhibit? 2-page exhibit?
Thank you. And that is all the questions I have for this witness at this time. Thank you.
Thank you. Ms. Vargas.
Good afternoon, Mr. Strickland. If there's any questions that I ask that are confusing or you don't understand them, just let me know so I can ask a better question.
okay,
Thanks. So you testified that Mr. Huddleston had been emailing you from June 13th to about June 15th, correct?
yes,
And during those email communications, you continue to respond to Mr. Huddleston, correct?
to some of them, not all.
Okay, but there was numerous responses during those several days that you responded to his emails, correct?
Yes,
And one of those responses actually from June 15th of 2021 actually said, "Oh, what's the matter? Is your whore gonna have to walk to her dates? Now prostitute life must be so hard."
probably.
Objection, Your Honor, relevance?
Judge, I'm impeaching the witness and it goes to her credibility in terms of continuous unconsented contact.
A lot.
You
Yeah, I said, probably I did. I don't remember exactly everything that was
was looking
said
at
and
the email,
not said.
refresh your recollection.
Yes, if I guess.
May I
yeah.
approach, Judge?
Sure.
Sure, I'll look at it.
Does that refresh your recollection?
Yes,
Do you have an extra copy of that?
I don't, but I did.
Sorry. Go ahead.
So you admit that that was one of the statements you responded to Mr. Huddleston with, correct?
correct.
And you also said, "It's my truck, I paid for it."
That sounds like something I said, yes.
And Mr. Huddleston also asked you to bring his truck or he would be calling the police, correct?
He threatened many times to call the police about the truck.
Is that a yes?
Yes,
And at any point during these email exchanges, did you tell Mr. Huddleston to not email you anymore?
yes,
Okay. Did you print up and provide any emails to the police in this case?
to the police, no,
Did you provide emails to anybody else?
no,
Okay. Do you still have the emails?
I would have to look, but probably.
Okay. Do you recall if the officers asked you to provide the emails at all?
I do not believe they did, no.
And so again, between June 13th through June 15th, there were numerous responses from you to those emails, correct?
Yes,
From Mr. Huddleston. And you voluntarily drove to Chaps Landing, correct?
correct,
And you had had contact with Mr. Huddleston for several minutes before you got out of the vehicle, correct?
correct,
And where you parked at Chaps Landing in the parking lot, you were actually the first parking spot in front of the front door, correct?
I don't remember exactly what spot, but I was close to the door, yes,
And Chaps Landing is a somewhat busy establishment, correct?
correct,
And there was numerous cars and numerous people going in and out of the business while you were parked interacting with Mr. Huddleston, correct?
correct,
And there were people that walked right by you, correct?
correct,
And cars that were parked next to you, correct?
correct,
And at no point did you call out to anybody for help, correct?
correct,
And you didn't try to go inside the business to ask for help, correct?
correct.
And it was only after Mr. Huddleston went to take the money and then you tried to grab the money also that you decided that you were gonna call 911.
After he tried hitting me, yes,
Okay.
or I'm sorry, after he actually hit me. and
When he
made
scratched your
contact,
lip.
yes,
Okay. And so this was how this whole altercation had to do with you getting money from Mr. Huddleston for the Blazer, correct? That was
for
impounded?
the, yeah, the impounding, me paying to get it out of the impound, yes.
Okay. And you and Mr. Huddleston, how long had you been dating, or how long were you together before this incident?
Almost 13 years,
Okay, and you had separated relatively close to June of 2020, correct?
we had, in June of 2020,
When did your relationship with Mr. Huddleston end?
Probably March of 2021.
Okay. Sorry, I said 2020.
That's how I was
Sorry, that was my
confused.
fault. So it was just a couple months that you guys had been separated before this incident.
Correct.
Okay, and Mr. Huddleston was actually starting to see somebody new, correct?
I don't know.
Okay. But you agree that you referenced your whore in one of his emails, correct?
Yes,
Okay. Can you see? Here. And so you testified that on direct that you were afraid for your life in the parking lot, correct?
correct.
But again, you didn't scream out to anybody, right?
No, I was on the phone with 911.
Okay. Before you were on the phone with 911, you didn't try to get assistance from anybody, correct?
Correct.
And there was several minutes of interaction between you and Mr. Huddleston before you called 911, correct?
No, not several, like maybe 2 or 3.
Okay. Did you roll your window down at all while you were interacting with Mr. Huddleston, or did you open your door?
My window was down about that far.
Okay,
Just for the record, she had her finger and thumb separated approximately 2
2
inches.
inches.
Sorry.
You're all right.
And then even after this incident, you still continued to have email, I'm sorry, let me rephrase that. After June 2021, you still continued to have email communication with Mr. Huddleston, correct?
I don't
Objection,
believe-
can we specify the date? Because this incident occurred in June 2021.
So in July 2021, you had email communication with Mr. Huddleston, correct?
No, I don't think so.
Okay, so, I'm sorry, I'm getting my dates. So after June 15th or 16th of 2020, did you have any further contact with Mr. Huddleston via email?
I don't remember.
Okay. Just one moment, Judge.
Sure. Remember to talk to me about December 20th.
And you personally did not complete any sort of proof of service for the PPO that was served on Mr. Huddleston, correct?
When?
In October of 2021. I'm sorry, October of 2020.
I didn't submit in October.
You personally did not sign and complete any sort of proof of service and filed it with the court regarding service of the PPO on Mr. Huddleston, correct?
From October, no.
Okay. Nothing further, Judge.
Ms. Marcicio,
Just a few follow-up questions.
I'm sorry, Judge. I have some video. I'm sorry, I have video that I wanted to admit by stipulation. Did you want me to wait until after the?
whatever works for you.
Okay, I'll let Sister Counsel finish.
That's fine.
And then I'll go through it afterwards.
Throughout your email exchange, did you, a part of your responses, was there a point where you shared that you didn't want contact with Mr. Huddleston?
Yes.
And what did you say?
I told him, I don't remember the exact wording, but I did tell him to stop emailing me, that I have nothing for him.
Okay, and is there any PPO against you?
No,
Did Mr. Huddleston ever get a PPO against you?
no.
And why did you choose Chaps Landing?
Because it was close to the police station, as I could get him to show.
Is there any other reason?
No,
When you were in your car, where exactly was Mr. Huddleston?
outside, on my driver's side,
So if you wanted to, could you have gotten out of your door?
not without pushing him out of the way.
Okay, and were you able to drive away?
No,
And why is that?
because he was on my bumper.
I have no further questions, thank you.
No, go ahead.
There were times during the interaction with Mr. Huddleston where he walked to the back end of the vehicle and by the back trunk, correct?
Yes,
And he was actually standing at the back end of the vehicle for a couple minutes, correct?
yes,
And he had his phone, right?
He did?
Yes,
I don't know.
okay.
I don't.
And he had placed some money on the windshield, correct?
Correct.
And that's when you testified that you went to go grab the money, correct?
Yes.
And he went for the money as well because you didn't give him the car keys as originally agreed, correct?
I don't know why he went for the money.
Okay, but you did not give Mr. Huddleston the car keys as agreed, correct?
Until he gave me the money, no. That's what the agreement was. He gave me the money, handed me the money, and I would hand him the car keys. He put the money under my windshield wiper. And until I could get the money, I didn't give him the keys.
Okay. But you saw him put the money under the windshield wiper, correct?
Correct.
And you did not hand him the keys, correct?
No, because I didn't have the money.
Okay, but it was underneath the windshield, right? Or the windshield wiper?
Your Honor, objection, asked and answered.
It was.
And then, I'm sorry, one second, Judge. I have nothing further, Judge.
Okay. Video?
Judge, I apologize. This is going to be not the easiest because the videos are cut up into clips varying from like a minute or 30 seconds to a couple minutes at a
Okay.
time. So there's a total of 19 different clips. I'll write out a list of all the file names and just give them to sister counsel so she has them for the exhibits. Does the court want me to, I don't know what the preference is for the court, for me to just read all the file numbers into the record, or?
Let's have another conversation. Give me an offer of proof. What's this 19+ minutes of video gonna help me with?
It's the actual surveillance video from Chaps Landing showing the altercation with Ms. Strickland and Mr. Huddleston. So
Okay.
there's two different camera angles. One is from the actual like front of the building angled towards the vehicle. And then the other camera angle is from underneath the gas pumps, also towards the vehicle, but it's two different angles.
Okay. So how's that gonna help me in a probable cause hearing? Do you think it's gonna affect my judgment of credibility of the witness?
I do, Judge.
Okay. Then as far as how we get those numbers into the record, dealer's choice. I don't care if you want to read them in, you want to give them to Heather so she can type them in.
I'll just give them to Heather because they're very, very long. So
That's-
I'll write up all the
You're
file
okay with
names
that?
and then give them to Heather and then sister counsel as well.
That's fine.
Okay.
Yeah, 36, okay.
Ms. Marcus, when you start playing, can you play up here with the speaker? Or so that the
There's
microphone-
no sound.
Oh, there's no sound, okay.
Makes that easier.
So, all right, so Judge, at this time, I would move to admit defense exhibits A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P, Q, R, and S. Or I don't know if you want me to just do it all as one, the problem, like I said, there,
You plan on objecting to any of them individually?
I was
No,
gonna be by
because it's-
stipulation.
It's all one clip, just different sections, so I think it makes more sense to just have one exhibit.
Okay,
That's okay. Makes it
Defense
easier on
exhibit.
Heather.
defense exhibit A.
Actually, I think she'll number it defense exhibit 1, but that'll work.
Oh, I'm sorry, one, yes.
So one exhibit, just a bunch of different little clips.
Yes.
Makes sense.
We can excuse Ms. Strickland.
Okay, you can step down and watch your step on that ramp.
No, that's fine. It's saying that I'm sharing my screen, but it's not showing up.
I've got it up here. I'm looking at a parking lot view.
Okay, as long as you guys have it, I think we're good. So just for the record, the date, the timestamp is June 20, 2021, time starting at 9:36:28 PM. And Judge, Sergeant testified that it was a white Buick Oakley, which is the vehicle on the far end of the video.
Okay. Furthest away from the camera.
Yes.
Got it. Luckily, it's the only white car there.
Do you both have this one up now?
Yep. Yep.
Okay. And Judge, the rest of this one is pretty much Mr. Huddleston being seen at the back end of the vehicle.
Okay.
The next one is pretty much the same until the police arrive. I think I'm good playing the rest of these or publishing these for the court.
However you want to do it.
Okay. this next video, I'm just going to jump towards the end when Mr. Huddleston comes into screen.
Okay.
And the rest of these angles are gonna be from the pump view jet.
Gotcha.
This is the last one, Judge.
Thank you.
And I'll just stop it at 9:47:25, and you can see the police cruiser has arrived. And Judge, defense has no witnesses.
Thank you. Argument?
Yes, Judge. The people believe that we set forth enough evidence to bound over this case on all charges. Starting with count 1 for the controlled substance of the meth. The Sergeant Hindley testified that Mr. Huddleston, or when he went to arrest Mr. Huddleston, he had his duffel bag with him. And pretty much had constructive possession of everything within the duffel bag, including the meth. It was processed correctly, submitted to MSP for testing. It came back as contraband, as narcotics. And so as the police report states, or sorry, the lab report states, it was meth, and that is a violation of MCL 333.74088. And therefore we believe we present enough evidence for count 1. And then as for count 2, the aggravated stalking, our complaining witness, Nicolette Strickland, testified that Mr. Huddleston made repeated and continuous contact with her despite the active PPO that was in place against him, that he was aware of, had notice of, and that PPO was certified. And despite having that in place, regardless of what the reason was, he continuously emailed Ms. Strickland requesting the truck, and she mentioned that she felt threatened and harassed based on the communication. It lasted for several days. And then finally, in order to make Mr. Huddleston stop the communication, she agreed to meet with him at the gas station that was near the police department. The video shows, her statement shows that when he put the money underneath the wipers, she went to reach it. He also, for some reason, decided to reach for the money at the same time, struck her, hit her in the lip, assaulted her, and therefore we presented probable cause to bound over all 3 counts.
Ms. Harvey?
Well, Judge, in terms of, just for clarification, the amended count, are the people moving for amended count 3 as the possession of the meth?
My complaint shows count 1 as possession of meth.
Oh, I'm sorry, you know,
It might be the old one.
it's the
because it
old
was
one.
added, yeah.
Okay, so, I'm sorry. So the possession of, the possession of meth is count 1, the aggravated stalking is count 2, DV is count 3.
Yep, that's the way I've got it. Yep.
For the aggravated stalking, Judge, first off, the elements that the people have to establish is first that the defendant committed 2 or more willful, separate, and non-continuous acts of unconsented contact pursuant to MCL 750.411I. That is the statute governing aggravated stalking. The definition under subsection F of unconsented contact means any contact with another individual that is initiated or continued without that individual's consent or in disregard of that individual's expressed desire that the contact be avoided or discontinued. And then it goes on to list several examples of unconsented contact, but it's not an all-inclusive list under the statute. Ms. Strickland testified, and I impeached her with the evidence that she had contact back with Mr. Huddleston, that she had specifically made a comment regarding another female that she referred to as a whore, and that she admitted that she did respond to Mr. Huddleston's emails. She also testified that she voluntarily initiated the contact with Mr. Huddleston at Chaps Landing. And my position would be that the people have presented insufficient evidence for the court to bind over on the aggravated stalking on that element alone. However, in addition to that, the people also have to establish that the contact would cause a reasonable individual to suffer emotional distress, and that the contact actually caused the complainant to suffer emotional distress. Again, I would argue that the people have not presented sufficient evidence to meet those elements. Ms. Strickland, it's clear from the video that she had plenty of opportunity to seek out additional assistance. While I recognize that she testified that she had called 911, however, there was plenty of other traffic and other people in that area that would cause a reasonable person, if they felt emotional distress or were in fear, as she testified, to reach out to those individuals for assistance, which she did not do in this case. And then the fourth element would be that the contact would cause a reasonable individual to feel terrorized, frightened, intimidated, threatened, harassed, or molested, and that the contact caused the complainant to feel terrorized, frightened, intimidated, threatened, harassed, and molested. In addition, there was evidence that, the people did admit the PPO that was entered in this case. However, I would argue that the knowledge and the proof that Mr. Huddleston was aware of it is not, the people have failed to establish that by admissible evidence. The people posited that there was other, information entered into lien and other knowledge that Ms. Strickland had that the PPO was served, but there's nothing that's been admitted with the certified copy of the certificate of service of the PPO, as well as the statement that the people presented for Mr. Huddleston. I would argue the court should consider inadmissible evidence under a violation of Miranda. The sergeant testified that he had, made comments and questioned Mr. Huddleston about him knowing the violation of the PPO, and he was not Mirandized before he was placed into the back of the police cruiser. He was under arrest, he was in custody and not free to leave. Therefore, he should have been Mirandized. And again, in terms of a valid knowing element of violation of the court order, I think the people have not established that. Going on to the domestic violence, their defense charge, the people haven't presented any evidence regarding prior domestic violence convictions for Mr. Huddleston. So I would ask that the court not find over on the DB third.
Thank you. Your turn. Start wherever you want to.
Okay, for the DB 30, it was my understanding that that's just a sentence enhancement, that there isn't a proffering of a certification that it's for the offense. It's a sentence enhancement, not a element of the crime. The crime itself is the domestic violence, which was shown that there was an assault or battery upon Ms. Strickland. Going to the aggravated stalking, the fact that there is the PPO in place is what makes it an aggravated stalking incident, and the fact that Mr. Huddleston violated that, it doesn't, Ms. Strickland testified that there were several emails throughout the course of several days. She did not respond to all of them. She responded to some of them, and during that time, she even told him to stop reaching out to her. That's what she testified to. She said to stop contacting her. He did not abide. He continued to harass her. He made threats that he would be at her house. And so in order for her to, in her mind, to end the harassment and to end the continued threats, she agreed to meet with him in a place where there was cameras, where there was people, where there, that was close to the police department. She took the precautions that she needed to. She stated that she felt threatened. The statute doesn't require her to seek help from other people. She didn't want to leave her car. He was standing behind her car. It doesn't require her to ask for help. It just requires for the victim to feel the list of things. And she testified that she felt threatened and that she felt unsafe because he was at her car, because he had already assaulted her. She closed the window, sat in her car and waited for the police to come. I don't think it requires her to have to get out of her car and ask for more help when she's already on the phone with the police. One more note. Also, there isn't any order preventing her from contacting him. The stalking is solely for the fact that there was a valid PPO in place. You don't actually have to show proof of service either. That's not a requirement. Actual knowledge is all that's required. The testimony was given by the sergeant that, which you admitted the first part of, where defendant made statements about knowing that the PPO was in place. I only played part of it, but the part that I played was saying that he was being set up. He said that he didn't have like a mediator to come facilitate it, knowing that he couldn't have been there. If he made that statement, I need a mediator, meaning that he knew that he shouldn't have been there himself and that someone else should have been picking up the car. Again, he continued to threaten her by standing behind her car, by reaching for her instead of just giving her the money, getting the keys and leaving. He didn't do that. He continued to put her in fear by remaining there behind her car. And so that's why, based on what we have to do for this standard for probable cause, the people believe that they have met their standard.
Judge, just one follow-up
Sure.
in terms of the knowledge requirement. The jury instructions specifically outline knowledge as a requirement in the instructions. So under the elements, there's the option to have committed in violation of a court order or committed in violation of a restraining order of which the defendant had actual notice. So the PPO would fall under the restraining order language of the instruction. Additionally, the instructions specifically cite People versus 3 THREATT. It's 254 Mishap 504 from 2002. Again, that case citing that a defendant must have actual knowledge of the restraining order.
Any response to that?
Well, he did have actual knowledge. She testified that she was there when the police served him with the PPO. He knew of it. He said it himself. He said it to the police officer. I don't think the issue is whether or not he had actual knowledge. That was made clear several times throughout various testimonies. And he even recognized that he was violating the PPO when he went to meet her because he kept saying that she was setting him up.
Right. Anything else?
I don't
Anything?
think setting him up can be inferred as that specifically, but
Well,
I agree.
it's in the court's
I
discretion.
agree. If I didn't hear anything else today, I heard Ms. Strickland say that she was present when Huron Township PD served him with the PPO at the police department. That's actual knowledge.
Judge, just a correction. I
Yeah.
don't think she testified that it was at the police department. I believe she
think it-
testified it was at her home.
It was at her home.
At her home.
Yeah.
You're correct. Okay. All right. Certainly, this case is not without some weak spots, but this is probable cause hearing, and I heard enough for probable cause hearing to bind over on counts 1, 2, and 3. AOI date is going to be on the 20th. Well, I'm setting it. I'm scheduling on the 20th. I don't know when it's going to be. They're still way off, aren't they, Ms. Marcus?
They're getting better,
Are they? Okay.
so it might actually be the 20th.
Okay, well, good luck. Bond is continued. Anything else, ladies?
No, Judge, thank you.
Just to, of course, continue the no contact order that is part of the initial bond.
Bond is continued.
Thank you.
Actually, Judge, I would ask the court to consider removing Mr. Huddleston's tether. I do understand that this is a stalking case. However, I think the facts outlined in the preliminary exam show that some of this was consensual contact on behalf of Ms. Strickland. I've talked to Mr. Huddleston about this case, and he now understands going forward he's to not have any contact with Ms. Strickland. I don't think a GPS tether is necessary for the safety of the victim in this case. And so I'd ask the court to consider removing the GPS tether.
What's the downside to the GPS tether? For another 2 weeks?
Well, Judge, I mean, I've had plenty of clients on tether now, as the court can guess. And With the delay of the case getting processed in circuit court, there is a tremendous amount of fees that are getting accumulated by defendants or the cost of his tether. Actually, Mr. Huddleston, when he was booked in, he had some cash on him, and the tether office actually took all of that towards the tether when he was first booked in, and he got released from jail with pretty much, that was all of his money that he had, and he had no money to be able to try to survive on when he was released from custody. Additionally, Judge, I know I've referenced the report to you before, but the Vera Institute report that was done for Third Circuit specifically outlines how tethers actually hamper a lot of the factors that actually prevent recidivism in terms of employment.
Right.
And it's difficult for people to find housing, those types of factors. And so given all of those circumstances, I would ask the court to consider that. And additionally, just physically, I've had a lot of clients just in the court. I know it's a convenience to be out of jail, but also, you know, to be able to have to charge up the tether at a certain time every single day, with the length of time that the tethers are staying on, I'm also seeing clients that have physical like atrophy on their ankles because of the tether. And so I do think it's a very significant hardship. And in this case, the need for protection of the public and the Strickland, I don't think just meets the needs to keep the tether on.
Response.
I think the tether is doing what it needs to, and removing that places our complaining witness in jeopardy. There was a reason why there hasn't been contact since this case has gone forward. And so the people, of course, would object to removing the tether. I understand the concerns that were stated by defense counsel, but a lot of those were generalizations, not really specific to defendant. There was nothing presented that it's preventing him from housing or preventing him from getting a job. It is my understanding that the GPS tether literally just prevents him from being anywhere near, or at least locates his whereabouts to be anywhere near the complaining witness. And so I don't see the side effects to the other things that were mentioned, especially in regards specifically to this defendant. I understand that it's an inconvenience, but also that's a consequence that comes with what we're going through in this process. And he has violated the PPO previously. He was arrested for violating the PPO. I understand that sometimes we have to take what the defendant says at word, but at the same time, prior actions show that maybe he cannot be trusted without the tether in order to ensure that he does not violate it. And so our preference would be to maintain the bond as is, at least until another review occurs. But as of right now, we don't see any benefits to removing it.
Thank you. Ms. Vargas, anything as specifically how Mr. Huddleston's being harmed by the GPS tether?
He's having difficulty finding employment. And
Where at and why? Where have you gone to get a job and if the tether prevented you?
I've been to KFCs, I've been to pizza places. I can't walk around with a big box on my leg without people understanding.
Let me see it.
And it hurts. Look, you can't even move this thing. This thing's like torture. Can't even move.
Okay, well, brother, there's no reason your pant leg can't cover that when you go to a job interview.
Yeah, but still, if I'm working and a piece of wood hits that and it knocks it off, I'm in trouble. And I'm paying money for this too. This is ridiculous.
Bond will stay.
Thank you, Judge.
Thank you.
Judge, do you have anything after us, or can I have a minute to sit down?
Yeah, no, you're all right.
Thank you.
I'm just gonna make my notes and clear out.
Thank you.
Madam Prosecutor, your exhibits,
Thank you.
they're not all yours though. Yeah, I think
Hers was, I believe, only.
hers was just a video.
Yeah. Thank you.
Yeah.
Or you can just go ahead and take off and I'll call you. I'll talk to you later.
And for your acceptance, let me know if you
Oh, don't go anywhere yet. I gotta give you the list.
Oh, okay.
Sorry, I'm almost through it.
Oh, that's good.
I swear the file names on these are like the longest possible names like ever. And these evidence.com file extensions are crazy because they just name everything so long. Can you just make a quick copy of this for me so I can get it to the prosecutor?
Yep. Right back. Thank you. Scan it. Just what the voice scanned in yellow.
Thank you. If you have any trouble reading any of my handwriting, just let me know.
Okay, yeah, that's fine. All right, thank you.
I'm just gonna take a picture of this and then we'll